Hi, welcome to the legal wing of Perchance to Read, where I read one word or legal term and quickly break it down for trial watchers. As I say each time, there's no focus on any one trial in this series, just the trial words. And as always, nothing in this video is intended to be legal advice to anyone about anything. Okay, let's jump right in. Sua Sponte is Latin for of one's own accord. It's got a 50-50 pronunciation rate, where half the people say Sua Sponte and half say Sua Sponte. Both are acceptable in any court of law. I lean Sua Sponte, so that's what I'll be using for the duration. And I'll just leave it on the screen, but simply put, when a court acts Sua Sponte, it acts on its own, of its own accord instead of at the request of a party in the case. There are limits on a court's ability to act Sua Sponte that are not necessary to cover here, but just know that it's not an absolute power. But if you're following a certain case and a ruling or a directive comes without you recalling that a party requested it, you may say, wait, what happened? What did I miss? It could be something the rules of court mandated. It could be something parties stipulated to, or it could be that the court ordered it Sua Sponte. So again, on its own, of its own accord. Sua Sponte acts by the court are more common than one might think and come up in cases, even if no one mentions the word Sua Sponte, more than people might realize. That's because when you watch fictional law and crime shows, it's usually the protagonist's case that drives the story, the trial, the law. We get some antagonist stuff in there too, but we're usually watching to see what the protagonist does. So rarely on TV does the court act on its own. There's no fictional drama in that. There's no fight. It would be like writing a movie about the big game and focusing on the referee, doing their actual refereeing, instead of the two teams playing in the big game. That's not how you would write your movie. Courtroom dramas are never about the judge acting as a judge. But in real life, it can and often does happen that a court will make motions in its own case, of its own accord, Sua Sponte. With some exceptions, parties often do not challenge a court acting Sua Sponte because the act may have cleared up something or been otherwise unavoidable based on the law. An example of the latter would be when the court, Sua Sponte, dismisses a case because the court has no jurisdiction to hear it. A court can also dismiss a case Sua Sponte for a party's failure to prosecute the case, meaning they didn't actively litigate. An example of a court acting Sua Sponte that doesn't lead to the end of the litigation is when the court changes a hearing date. The court will, Sua Sponte, move to change the date, and then just change the date, all within the same order, maybe with just a few words along the lines of, on the court's own motion, the hearing set for X date is now set for Y date, and nothing else.
It was 2:16 p.m. when we got back to the Hall of Justice, Superior Court, Department 38.
These are often no-ceremony moments that won't make the news, akin to our referee from earlier waiting a few extra moments before throwing up the starting jump ball of a basketball game so a player can tie their shoe. No one from either side of that game needs one player out there with their shoe untied, so everybody waits, the shoe is tied, and then game on. Shoelace event a necessary precursor to the actual game. And even if you wanted to object so the other side would trip over the loose shoelace, you know the ref isn't going to let the game be played that way, so you wait for the player to tie their shoe and start the game later than scheduled because the ref, Sua Sponte, said so. A court can also move Sua Sponte to sanction a party. A final example I'll give is when the court orders more briefing Sua Sponte. Parties may have taken their first crack at the case and filed their official briefs, but a court may need more information or want to hear more about what parties have to say on a particular issue. Without one side or the other moving to file another brief, the court will simply, Sua Sponte, on its own, of its own accord, request that parties file more briefs. So in a nutshell, when a court acts Sua Sponte, it's likely patching over an inadvertent hole in the process or course correcting a party or the overall case. You can often recognize a Sua Sponte order in a trial you're watching because it will be an order issued that's not based on any party's filing or on a rule of court that requires it. An order is simply entered, file more briefs, or the hearing is rescheduled, and you know the court acted on its own, sua sponte, or likely did. Again, there can be procedural exceptions to this power based on the proposed sua sponte action, and other exceptions not relevant for our simple definition. But this is the general gist of what sua sponte means, and just a few examples of how you may see it play out in a case. And there you have it, sua sponte, or sua sponte. If this was helpful, please hit that like button. Links to my other trial watchwords are above and in the description. And it bears repeating, nothing in this video is intended to be legal advice to anyone about anything. Thanks for watching.